National security versus individual liberty. Who shall win? Well, the courtroom drama regarding the bail petition of Sharjeel, Imam, and Umar Khalid when it comes to the Delhi riots of 2020 was not just another highlight into the case. It was once again a big question considering India's most powerful law against terrorism, that is UAPA, Unlawful Activities Prevention Act, versus the Constitution's sacred guarantee with regard to the freedom as well as fair trial. So, what has happened? First of all, guys, my name is Praveen Mishra, and I welcome you all to StudyIQ IAS English. And here is the whole scenario. The bail petition of the two activists, Sharjeel, Imam, and Umar Khalid, has been denied by the Honorable Delhi High Court on the grounds of alleged conspiracy behind the February 2020 riots in Delhi. This is what the scene is. Yes, you had heard, you're just reading it right. Alleged conspiracy. So, what's the whole scenario? Arguing on behalf of Delhi police against the bail petition of the accused, the Solicitor General Tushar Mehta, exactly on July 9, 2025, told the Honorable Delhi High Court that the accused must remain in jail until they are either convicted or acquitted, as in either they are proven guilty or they are not proven guilty. And so the prosecution vehemently opposed the bail petition, saying it was not a case of spontaneous riots. But as you can see, the words that has came from the opposition, it's a case which was, literally representing planned well in advance with a sinister motive and a well thought out conspiracy. This is what the additional, or basically the Solicitor General Tushar Mehta has stated. How much you would agree to this statement? Let us know in the comment section for sure. We shall be waiting. And now let's talk about this case, the constitutional analysis of the Delhi case. So, in denying bail to Umar Khalid and Sharjeel Imam, the Delhi High Court applied Section 43, capital D, Clause 5 of UAPA. What is this basically? It says simply that bail becomes exception and jail becomes a general norm in the UAPA case. So basically, in any general case, bail is a right and jail is an exception. But when it comes to UAPA, specifically Section 43, capital D, Clause 5, here the coins are flipped. Jail is a norm and bail is an exception. Yes, it is contradictory to Article 21. But yes, when we talk about the procedure established by law that has been mentioned under Article 21, which basically explains no person shall be deprived of his life and personal liberty except by the procedure established by law. This thing was subsequently changed by the Supreme Court through its interpreting power in the Maneka Gandhi versus Union of India case 1978. Now we follow the due process of law. But the fact here is, the remnants, the eclipse of procedure established by law is still followed by our constitution. And taking the inspiration from such a thing, we have got Section 43, capital D, Clause 5 of the Unlawful Activities Prevention Act that says bail becomes an exception in the UAPA cases. And now let's talk about the constitutional position of the UAPA. So bail under UAPA is an exception, not a single norm. Okay, so as you can see, once again, the clause remain the same. Section 43, capital D, Clause 5. Bail must be denied. As you can see, the wordings must be denied if the court finds the reasonable grounds to believe that the charges are prima facie true. Now, this is contradictory in nature. How and why? First of all, any investigation should be always based on the in-depth analysis, and the court's judgment is always based on the in-depth analysis of the investigation. But in the UAPA case, even if the investigating officer or the investigating team has stated that they don't have the in-depth analysis of the case, of the incidents or whatsoever thing, but they do have the prima facie grounds against the accused, then in such a case, bail can be just and just simply denied. This is what the section 43 capital D clause 5 is. We must take the section because it is a severe section for sure. But it is contradictory to the individual rights guaranteed under Article 19 clause 1 subclause A, that is freedom of speech and expression. But here, whenever denying the bail through the UAPA, where bail becomes an exception, the judiciary follows the doctrine of reasonable restrictions. Specifically, if we talk about Article 19, Clause 3, 4, 5, and so on. Well, you have your own liberty, your own personal freedom. But remember, your freedom, your liberty should not be coming in the way of national security, internal security, national sovereignty, basically, communal harmony, unity and integrity of the nation, as well as the dignity of the individual, as well as the community. In any ways, if your freedom, if your liberty, if your rights, they are violating, infringing, abridging, or abrogating the rights, liberties, life, security, and sovereignty of the country as a whole, then we are sorry. Your liberty would be taken away. And this is what the doctrine of reasonable restriction simply explains. And through this, we have got the section 43 capital D clause 5 of UAPA, right? So we have also just taken into the consideration the A.K. Gopalan versus the State of Madras case of 1950. That's the most simple thing, where Supreme Court clearly explained that, remember, your Article 20 clause 1 as well as Article 22 clause 3, they could be contradictory in nature as well, but on the grounds of maintaining the internal security, your liberty could be kept aside. So now remember, as I stated in the beginning, national security versus individual liberty, who shall win? So it will be always and always national security and sovereignty. And this is what the scenario is when it comes to the Supreme Court's affirmation of the constitutionality of UAPA. In March 2023, Supreme Court itself declared clearly that even if you are not indulged in any kind of physical violence, but just you are, or merely you are a member of any kind of a banned outfit, a terrorist outfit, or an extremist outfit, it is a sufficient ground to prosecute you, to try you through the UAPA. And the very same thing was followed, the very same footprints was followed by the Bombay High Court in July this year, okay, affirming the constitutional validity of UAPA. So who is winning? Always it is national security that is winning. And here comes the final tension, the absolute stress. Rule of bail versus national security. So the general criminal law, remember, a general criminal law, okay, bail is the rule and jail is an exception, right? But here, UAPA flips the coin totally. As you can see, in the UAPA, bail becomes the exception and the accused faces the heightened burdens of imprisonment. Because here, bail is a norm, jail is a norm and bail is an exception. And so, since last 5 years plus, activists like Sharjeel, Imam and Umar Khalid, they are facing the prosecution, the trial, and they are being imprisoned. And their bail petition has just been denied by the Honorable Delhi High Court. Let's see whether these people shall be approaching the Honorable Supreme Court or not, when and if, and what will be the judgment of Supreme Court. But whatsoever the judgment is, please do let us know your opinion into the comment section. And yes, finally, if you are a serious UPSC CSE aspirant, so this information is for you. Our resolution batch is about to commence from 3rd of October. First of all, let me be very precise. Our resolution batches are commencing from 3rd of October. So if you're an aspirant for 2026, here we have got for you Hindi medium, English medium, bilingual, doesn't make any difference. If you're an aspirant for 2027, we have got the same. from 3rd of October. If you're an aspirant looking for 2028 of the examination, no worries. From 3rd of October, all the 3 batches are going to commence. That is the GS Foundation P2I batches. Okay, 1000 plus hours of live classes, access to recorded lectures, teachers, personal class notes will be shared with you at the end of the session in the PDF format. 18 sets of printed books will be given to you. Obviously, will be sent to you at your doorstep. You don't have to go anywhere to collect them. This is the knowledge enhancement part. Let's talk about the assessment part. 75 plus tests for your prelims, 15 plus tests for your mains, and multiple mock interviews for your personality test. That is basically your interview again. And now, the most beautiful part. 1:1 mentorship is also included under this one subscription, under this one batch, as well as the mains residential program, as well as the prelims residential program. Both of them covered under one single subscription, that is the resolution batch. So guys, quickly enroll yourself. That is from today onwards, that's 3rd of September onwards. We are commencing our resolution batches for 2026, 27, as well as 2028 examination year of aspirants. So guys, remember, whatever subscription you are choosing, we have got multiple subscription plans starting with gold, platinum, and diamond. So the prices that are starting with, they are just rupees 9,999. What you need is with yourself is the promo code, that is PRV Live. So guys, just go ahead and apply this promo code PRV Live and get the maximum possible discount on all of your subscriptions on any subscription on our StudyIQ platform. Right, everyone? But before you leave, don't forget to hit the subscribe button of our channel, StudyIQ IAS English. And in case you wish to connect with me, here is the QR code for my Telegram channel, that is Praveen_StudyIQ. And here is my Instagram account as well, that is Praveen Mishra_2107. But guys, please hit the subscribe button and never miss an update from the channel. Bye bye. Good day. Take care. See you soon. Jai Hind. Jai Bharat.